talking about what indices of racial discrimination should we use, and Horace thinks it's very problematic to use this just basic index of how many African Americans are elected.
Right. The truth is, Chris, that Horace's argument is wholly meritless. It's because, to Pastor Jones's point, in Alabama and other covered jurisdictions, one expression of people of color's vote is the ability to elect their candidate of choice, who at times may look like them if they're African Americans. And what we saw in the seat of Calera in particular is that where voters of color, their African American voters, sought to elect their preferred candidate of choice, who was African American, the city sought to take that away through enacting a discriminatory redistricting plan. Right. And this is a significant feature of Section 5 as it acts as our discriminatory checkpoint for our democracy.
And someone who worked at the Justice Department enforcing this, is it right that that's the...
Look, the focus of the inquiry is always what does the minority community want? So Latino voters, African-American voters, who's their candidate of choice? That's what we look at. So you look to see what do the voters want. This is not some kind of patronizing or sort of determination that, of course, black folks want to elect black people, Latinos, Latino people. It really looks at actual voting patterns. And the thing that's true, and often true in many of the Section 5 jurisdictions, at levels it's not true in other places, is that the minority communities are trying to elect candidates that the majority community will systematically reject. Right. And so you have to find some way for them to have a political voice.
Can I just make one larger point, which is this is not a grassroots uprising against the Voting Rights Act. It's not like suddenly all the people in Alabama and Mississippi wanted to challenge the Voting Rights Act. Right. This is a product of the conservative industrial complex, right? The fact that you have the largest funders in the conservative movement, the same people that were pushing discriminatory voting changes, they want this challenge to happen, and that's why it's before the court. So there's really no constituency for this challenge other than the biggest names in the conservative movement.
I think one of the things that people may be looking at is the fact that it seems as though they think that we're just want you to give us something. We're not asking you to give us anything. All we want is the opportunity to make the playing field level, give the opportunity to the citizens to make decisions.
Horace, are you constituency-less as Ari charged?
It feels good while we're drinking coffee and having a conversation this morning to make those kind of banal statements. But the truth of the matter is, whether it is lawsuits against the Vietnam War, whether it is the right of men to marry men or women to marry women, whether it is any claim, if we left litigation only to circumstances where it was popular, most of the landmark litigation that we see and we appreciate today would never take place.
No,
so that's a specious standard that is not popular. The point is there are legal principles that are at work. Now, if this Justice Department would have remembered that the Voting Rights Act was intended to stop the number of fire burnings, the number of lynchings, the number of shootings, and actual voter intimidation techniques that were occurring, that were predominant in those areas, instead of deciding that a new modern approach is this holistic idea of what does the voting population want, they would be on much stronger ground. You can be black, white, or brown and ask a poll about, say, voter ID, and you'll see that number in the high 60%. Yet every one of your panelists is opposed to voter ID. And so when the Justice Department denies a state the right to be able to carry out it, it raises those fundamental constitutional questions.
Chris, I would say there's nothing inconsistent about what Congress did in 2006 when it considered whether to reauthorize Section 5, which was that it looked at the tremendous progress that we've made in this country in our democracy in ridding of racial discrimination, and yet recognizing the need for more. And Section 5 in particular has occasioned the type of progress we've seen since 1965, but it itself, the strong antibiotic that it is, seeks to continue the work that it began in 1965. The record Congress developed showed that there were more than 1,000 discriminatory changes that were blocked as a result of Section 5. And those discriminatory changes would have gone into effect but for Section 5. Section 5, in a very real way, to Pastor Jones's point, protects real voters from real discrimination in real places.
Please.
And we're where we are because of Section 5. You know, the South wants to paint the picture that we're all holding hands singing Kumbaya in the South. That's not the truth. There are still issues that need to be dealt with.
Horace, can I ask you this? We have a little bit of time. Just this final question. If the challenge is successful, if the court were to strike down Section 5, and 10 years from now, in some bizarre future in which I still have a television show, and you come back on the program and say say the number of black elected officials in the South has dropped 80% in the wake of Section 5 being struck down. Will you view it as a mistake if all these metrics go down, or is the principle here the point?
The principle is the point. And by the way, once we get to this question of racial voting and that being the test, where does it end? Are you going to invalidate the presidential election of 2012 because over 90% of blacks block voted for a candidate of their same color? Where does that quest stop? You absolutely ought to stick with what the law says and what the underlying principles are associated with it.
Horace Cooper with the Project 21 National Advisory Board, thanks for joining us this morning.
Thank you.
Ari Berman from The Nation magazine, Julie Fernandes, former Deputy Assistant Attorney General Ryan Haygood of the NAACP Legal Defense and Education Fund, and Bishop Harry Jones, a party to the lawsuit in support of the Voting Rights Act. Thank you all for joining us this morning. It was a really great conversation. I learned a lot.
Thanks for having us.